Hey, it's What's Up Wednesday with James, and today I'm in South Carolina, Greenville, South Carolina, at the South Carolina Board of Realtors Annual Conference. And of course, I every week want to bring strong value to you in regards to broker matters and things of that nature. Oddly enough, recently we got an audit from the Georgia Real Estate Commission, which consisted of a 26-page questionnaire that I had to complete with 7 tasks. And all that was finished up. The last item was number 7 task was an affiliate notification to the broker of the personal real estate activities. And that's a 3-page document that we had to send out to every one of our agents, and those had to be completed. And for any of my agents that are watching this video, you have to make sure you complete this item, and it has to be filled out properly, completely, and signed. So make sure that if you have not gotten that back to us yet, that needs to be done ASAP. Set everything aside and get these 3 pages right here back to us. Couple points today. This is going to be a little bit longer video than usual because we are going to talk about property management and the rules and regulations set forth with GREC in regards to a licensee trying to manage property or not being able to manage property. So I want to go through some things with you today. Please, again, my Southern Classic Realtors agents, you got to get this filled out. When I compose all this information on this last item, number 7, and submit back to the Real Estate Commission, it specifically asks who has not filled this out. They want the name, the real estate number, and the reason why. And there really is no reason why you shouldn't get this back to me. So make sure that you have all this back to me no later than this Friday. This Friday has to be in my hands. No ifs and buts about it. So, all right, let's dive into this real quick. Of course, the very first thing that I want to bring to everybody's attention in real estate license law is Rule 520-111. It states no licensee shall be permitted to list, sell, buy, exchange, rent, lease, or option or offer to list, sell, buy, exchange, rent, lease, or option real estate either in individuals or multiple parcels in the licensee's own name or in the name of any other firm or entity in which the licensee is an officer, employee, beneficiary, or member of such firm or other entity acting as a principal without first advising in writing or email the broker for whom the real estate licensee is acting. So what that means is if you as a licensee with my firm are thinking about buying or selling, leasing, anything to do with real estate, you must, before you do it, you have to put it in writing, send me an email saying, hey James, I'm about to sell my rental property on 123 Main Street, or I'm about to purchase a new property, about to purchase my primary property, about to sell my primary property. Whatever it is that you're doing, you must put that in writing to me prior to do that. Failure to do so could result, and most likely will result, in a fine from the Georgia Real Estate Commission, and you don't want to do that. So this document basically wants to know past year, have you sold any property? And there's some questions in regards to that. The next item that I want to talk about is property management, and that seems to be one of the biggest concerns across our company and across a lot of agents that I've talked to that really just want to make sure that they have a firm understanding of exactly what they're looking at when they're wanting to do property management. First and foremost, a licensee cannot do property management whatsoever for anybody other than themselves. If you own a piece of property and you're renting it and it's in your name and your name only, or in your LLC, and you have full ownership of that LLC, you can manage your own property. But if your spouse is on that with you, you can't manage it. If your best friends own there with you in title, you can't manage it. So if there is a joint ownership, you cannot manage that property whatsoever. It's spelled out in the real estate rules and regulations under license law, which is Title 43, Chapter 40. It's also listed in the rules and regulations of their Chapter 520. So, and by the way, you are a professional licensed agent. You have a responsibility and you're held accountable to know license law. And so if you haven't taken the time to sit down and read it, you can go to Greg's website. You can read License Law 520. It's all there with the rules and regulations. There's a lot of them. But you need to know those, and you need to make sure that you're practicing real estate following those rules and regulations set forth by the Georgia Real Estate Commission. If you're in South Carolina, Alabama with my firm, you need to be following those rules and regulations as well. You can go to Total Brokerage, go to our forms library, and our rules and regulations from Greg that they gave us is in there. So there's no excuse that you don't have the ability to read those. The question is, are you going to read them? And the answer is, you better dadgum read them, because if you don't, you could be setting yourself up with a lot of hurt and anguish from the Real Estate Commission, because they will fine you. They will cause you to have continued ed. And if you don't follow those rules and regulations, they could revoke your license and take you out of the business, which I don't think anybody wants that to happen. So let's get back to property management. You own a piece of property. You can manage that property, no ifs, ands, and buts about it. There's a caveat to that. You have to also have a separate escrow account, trust account. You have to go to the bank and open up an account with a financial institution lending organization, a Synovus Bank, a Bank of America, a Wachovia, a Regions Bank. I don't really care what the bank is. You just have to do that to hold that security deposit. You can't commingle any other funds in there. So if you rent a piece of property and your security deposit's $1,000, that $1,000 has got to go in there. It's got to be accounted for. And every quarter, you have to send me, as your broker, a reconciliation of that account to see that, yes, I have a property 123 Main Street. I have a tenant in there. I'm holding $1,000. That has to be sent to me every quarter per Greg. It's your responsibility to do it. Make sure you're doing it. Okay? So if you own the property, security deposit has to be in your name. It would be, for example, James Hamby escrow account. That's how you would set it up at the bank. That goes in there. Once a quarter, you send that over to me to review. Make sure you're doing that. If your husband is on that property with you, you can't manage it. You can't manage it. You're like, what do I do? Well, either A, you've got to quit claim the property back into your name, to where it's solely your property. And you're like, well, I don't want to do that. Then you have to give the property to a property management company and let them handle it. It's cut and dry. It's one or the other. But you cannot manage anybody else's property as a salesperson. You can, if you decide to get your own brokerage license, you can open up your own real estate company. I've got a couple agents that do that. They have their own broker license. They set up their own company for property management. It's totally separate. So they're a qualifying broker under their own firm for property management purposes. And they leave their license under my firm as an associate broker and do all their real estate sales through my company, which is perfectly legal and perfectly fine to do with the Georgia Real Estate Commission. But the biggest issues we're finding is that most of my agents, I won't say most, some agents have a joint ownership in a rental property and they're managing that property. And we got to get that cleaned up. If you're doing that, you're clearly in violation and you need to immediately contact an attorney, get that property quit claimed out of your spouse's name, all back in your name. Make sure you got your security deposit account set up as an escrow account with the bank. Make sure you're sending that over to me. And these questions relate that. Do you currently have a trust account? Yes or no? And if you don't and you're managing property, you can be in a lot of trouble with that too. So please make sure that you're following these rules and regulations. We send them out to you because Greg is doing the audit and they have the right to do that with a brokerage firm every 4 years. The monthly reconciliation statement is found under 520-1-08, monthly reconciliation of trust accounts. A broker required to maintain a trust account, escrow account, shall cause to be made at least monthly a written conciliation report and keep it. Now, in Southern Classic Realtors, we don't do that. I don't hold security deposits. I don't do anything with property management. I have no interest, no desire, nor will I ever. do that under my reign. As far as a trust account is concerned, Southern Classic Realtors does not have a trust account either. We're not going to hold security deposits. We're not going to hold earnest money. We just are not going to be in that business of doing that. There's too much liability, too much headache, and we elect just not to do that. So if you are in a position that you're like, I don't want to split up my property, me and my husband own it, great, you don't have to, but you got to find somebody else to manage that property. So I highly, highly recommend that you make sure that you read these laws that set forth. You've got to follow them. There's one more I want to read that's interesting. It says right here, based upon section 43-40-20, it authorizes a non-broker licensee to open a trust account for the deposit trust funds received on the properties for the non-broker licensee who owns if the broker holding the non-broker licensee approves the opening of such an account. And I will. If you need to do that, I'll approve that. And if the non-broker licensee provides the broker with regular reports accounting for the funds in such an account, which has to be done quarterly per GREC. The commission shall deem a property owned by a licensee if the deed, now listen to this, if the deed of the property reflects either A, only in the name of the licensee, or B, only the name of the business entity of which the licensee is the sole owner, member, or stockholder. Got it? So you either have the property in your name or in a company name that's solely yours. Whenever a licensee owns an interest in a property that is less than 100% ownership, excuse me, and receives any trust funds of such property, such licensee must deposit those trust funds into the trust account of a firm licensed under this chapter, which again, we're not holding security deposits. We're not holding escrow deposits. So that's not going to be the case with us. If you don't own that property outright to hold that security deposit, you're going to have to place that with another property management company. So it's kind of cut and dry. You know, I think black and white, it spells it out pretty good. And again, I recommend that if you own property management and in that business and you've got properties, you better make sure that you follow up with these rules and regulations. Make sure that you understand what's going on and follow those. I actually read this morning that there is a long list of fines that the Real Estate Commission can impose on a person that doesn't do that. Failure of a community association manager, a salesperson, or an associate broker to notify the broker of personal real estate activities is a fine of $600. If you don't let me know that you are about to buy or sell property, the Real Estate Commission can fine you $600. They're probably going to make you do licensed law, continuing education credits as well. So there's just numerous potential fines out there that failure of a licensee to register with the GREC an account in which trust funds have been deposited, another $600 fine. So let's talk about that real quick, and we're going to wrap this up in just another couple minutes. When you set up a trust account with a bank, you have to make sure that you get my permission to do so first and foremost. And number two, once you get that set up, you must send me the bank name of the institution, the account number, and the date it was opened. And I have to then go in and register that account through my firm with the Georgia Real Estate Commission. And that will keep you and I both in the good graces of the Real Estate Commission. So make sure that number one, these 3 pages, the third page doesn't have to be filled out if number 2 is marked no. But if on page 2, number 2 is marked out that you own management property, you've got to complete this information. And no, you can't put it on an Excel spreadsheet and send it to me to attach this. This is not a James Hamby Southern Classic Realtors documents. This is the Georgia Real Estate Commission's documents that is required by you to fill out and send back to me so that I can collectively put this together for almost 500 agents and send in to the Georgia Real Estate Commission. So they're going to see this. And then I have a separate page, is page 22 of that 26 pages that I had to fill out, that I got to compose all this material and give them the questions that they want answered on that one page. So that's why it's absolutely required to get this into me no later than this Friday. Now, the good news is, as of yesterday afternoon, Jason told me that we've got about 75% of my agents that have already completed this form and sent it to it. If we send it back to you, that's because you didn't fill it out properly. So be on the lookout for that. But 75% of our agents within about a 24-hour period of time took care of this, and thank you for doing that. I truly appreciate that. Jason appreciates that. For those of you who have not, for whatever reason, you got to do it. You got to do it. Let me say it again. You got to do it. And if you don't do it, and when I send it in, I'm going to let the Real Estate Commission know. I have to let them know your name, your license number, and the failure of why you didn't do it. And the reason you didn't do it is because you just didn't do it. And they'll have to take that up with them. And I'm not trying to be ugly and rude when I say that, but I'm running the business that is mandated and watched over by the Georgia Real Estate Commission, as well as Alabama, as well as South Carolina. And when they ask for something, we've got to make sure that we get that taken care of. So today we've talked a lot. We've been on there over 16 minutes. I do apologize for that time, but it's very important. I hope that everybody gets strong value out of this. Make sure you're following the rules and regulations set forth. It's your license. You know, I'm sharing this with you. I'm doing my job. If you decide not to do your job, it's just like driving down the road, you come up to a stop sign. If you don't stop at that stop sign and you run it and there's no police officer see you there, you might have just gotten away with it. But eventually, you're going to get caught. And when you do, you're going to have to pay a ticket, a fine, and everything else. So this is no different. Whether you're speeding, running the red light, running the stop sign, whatever it is, these rules and regulations are set forth for you. You have to follow them. We have to protect the consumer, whether it's the buyer or the seller, the tenant or the landlord. We have to make sure we're doing our job properly, following the rules and regulations that set forth to us for the license that we maintain in our respective state. So again, I hope this has helped. Thanks again. It's been a great meeting. I appreciate you. I'll see you again next Wednesday. If you need anything, don't hesitate to reach out to us, and we'll talk to you soon. Take care. Enjoy your day. See ya.